Well, good afternoon, everybody. My name is J.D. Hensarling. I'm one of the lawyers here at Vann Attorneys, and I'm excited to spend a little bit of time with you this afternoon talking about litigation preparedness. It's something dear to my heart because I'm a litigation attorney. My practice focuses on primarily civil litigation, so that's business disputes. And many of you have experienced those or soon will experience those. So look forward to talking to you about this. Also, it's important, we want to hear from you. So while I have some slides to go through and some information to share that I think is important, I want to hear from you what you think is important. So if you will, let us know you're listening. Drop a comment or a question to us. You can do that by using your GoToWebinar panel in the chat feature there, or you can send your questions by email to webinar@vanattorneys.com. There's somebody monitoring that account, and will send those questions to me to make sure I get those, and hopefully I'm able to answer those before we get off here. If not, you can send us questions and follow up afterwards. You can call us and ask to talk to one of our attorneys, or you can send an email to that web address. So webinar@vanattorneys.com. Also, we sent out by email the slide deck and some of the information for today's presentation prior this afternoon or prior to today. If you did not get that information or lost it, it will be published on our website shortly after this presentation, along with a video recording of this presentation. So if you want to watch it again or share it with somebody or have some questions, you can certainly access that on our website. And then also I'm told that it'll be sent out in an email to our listserv. And so you can access that too by clicking on a link. So with that, why don't we get started? Here are some of the topics we're going to discuss today. We're going to talk about anticipating litigation. We're going to talk about a readiness plan. We're going to talk about when to act and what are the triggers there. We're going to talk about the key people in your organization who should be responsible for acting. We're going to talk about the systems that are implicated when a claim arises. And then we're going to talk generally about litigation and what can happen if you and your organization were to respond in a timely manner, and then what would happen if your organization did not respond in a timely manner. And that can be an unfortunate circumstance for sure. So first tip I would say today is anticipate litigation. It is coming. Kind of like Game of Thrones, winter is coming. Litigation is coming. And many of you have dealt with litigation on one side or the other, or both. You've been the party who has sued, you've been a party who has sued, or you're contemplating suing, or soon a lawsuit's coming. So it will happen to you. Litigation, the numbers are on the rise all over the country. Here in Wake County and in North Carolina, the litigation numbers are high. And so there's a real good chance that litigation's coming to you. It doesn't matter whether you're a small business, medium-sized business, a large business. Claims are no respecters of the size of your organization. And if there's a claim, it will be brought no matter who you are, whether you're mom and pop gas company or Disney. It's coming. So just be prepared. Also, litigation spending is increasing for companies, and that's a function of the fact that there's more litigation out there and it's more expensive to deal with, but it's also because companies are not prepared for litigation. They don't anticipate litigation, and so when litigation happens, they scramble and spend a lot more energy, stress, time, and money getting ready for that litigation than they should if they were ready. So we're going to talk about some tips and some ideas for you to think about as you get ready. So the first thing I would say is know where your risk is. Sitting here today, I don't know what your company's or your individual risks are. I can certainly talk to you about those things, or our attorneys can talk to you about those things, but there are some known risks that you know based on the type of business you're in. Maybe it's a customer or a client. Maybe it's complaints about a product or a service that's being provided. You know, maybe you're a home builder, and you know that the complaints come from, you know, the parties that you build homes for. Is it subcontractors? Are those folks that work with your business, or you hire and contract with to work with your business? Is your risk your employees? Do you have employees who are registering complaints or filing claims against your organization because of the nature of the work you do? Maybe OSHA violations. Maybe they're not happy about the working conditions in your warehouse. So that's something to think about. Maybe it's regulators. Maybe you're a bank, credit institution, and you've got extra regulators, both federal and state regulators, and they're always looking for ways to get in there and see whether you're following the regulations. That may be your risk. Compliance with federal law, compliance with state law, compliance with revenue laws, taxes, or property taxes, revenue taxes. Maybe it's international law. Maybe you have a multinational corporation, and compliance is a potential risk for your organization. So, you know, whether it's local, regional, national, state, cross-border, you know what those risks are, and maybe you see exposure, potential exposure in one or more of those areas. There are others. So I would say ask yourself that question of your organization. Where are your risks? And that's how you can begin to anticipate where litigation or claims may come from. When do I need to act? That's important too, because deadlines, as you know, can be critical. First of all, let's talk about a duty to preserve. Preserve what? Jelly, peaches, strawberries. It's strawberry picking season here in North Carolina, but that's not what I'm talking about. I'm talking about your duty to preserve information, hard copy information, and electronically stored information. We refer to that as ESI. And courts are very, very clear that if a duty to preserve is triggered and your organization is not preserving the information it should preserve, there could be harsh consequences in the courts for that. Typically, what we look at is the reasonable anticipation of litigation. Did something occur or was something said that reasonably put your organization on notice that litigation is anticipated or is possible? There are certainly other triggers, but that's the general trigger is, do we anticipate litigation? And if so, then our risk team needs to go into action. How do you define and recognize these triggers? Well, that's a case-by-case basis, depending on what industry you're in, depending on what your business is, and depending on your answers to the questions on the previous slide, which is, what are your risks? There are some obvious triggers, right? A lawsuit's filed or a subpoena is served on your organization. What about more subtle triggers, like a meeting that didn't go well with a partner or an executive or an employee? What about a conversation where something was said, maybe in a meeting? What about an email that was taken the wrong way by an outside party or someone within your organization? Those are possible triggers to your duty to preserve information. I mean, it's easy when the CFO of your organization stands up at the board meeting and says, I can't take any more of this. You've been treating me poorly, and walks out the door and slams it. But sometimes that's not the way things happen. What about mixed circumstances? What about a termination of somebody from your organization that you think is a justified termination? And you're not worried about whether they're going to come back and sue for discrimination or wage and hour violations or Title VII violations. You need to watch out for those. An accident occurs at your plant or your place of work, or while somebody's driving a company car, and insurance takes care of it, or you think you've taken care of it. But what happens if litigation happens after that? So what I would suggest to do is define the triggers that are most likely in your organization. We can help you do that based on the answers to the questions, which is what are your risks? And then I suggest documenting those occurrences. And I suggest documenting those occurrences as part of a legal function so that they might be protected as attorney-client or work product, investigative privileges. And then also, one thing you might need once you have become aware of an action that might happen, you need to send out what's called a litigation hold notice. You need to put your organization on notice that either litigation is here or litigation is anticipated, so that they can begin the process of preserving the information that's necessary and relevant to those particular events. So let's look at a litigation hold notice. Looks like these two guys are at it again. Captain America and Iron Man are fighting again. And I don't know about you, but that upsets me. And so because they're fighting, they're about to be in litigation, so they can reasonably anticipate litigation. So both organizations are going to have to send out litigation hold notices. But because your organization is part of the umbrella under which these two work, you are Marvel Inc., you're going to have to potentially preserve information. So what are we going to do? We're going to send out a litigation hold notice to our organization. And this is going to come from an executive at the company or a legal function at the company. It can even come from outside counsel and be distributed by your chairman, your president, your vice president, but somebody who's going to be able to get notice to and communicate well with the people in your organization, and particularly those people who are responsible for the functions that are implicated in this litigation. So let's take a look at this. This is a sample that's on the Wake County Courts website, and I pulled it off of there. And it has some of the elements that we include in our litigation hold notices that we send out or draft on behalf of our clients, but you can use this as a go-by. And I've highlighted here some of the more important elements in these. I mean, I think that all of these points in this litigation hold notice are important, but let me explain a few of them to you. You may be familiar with this. You may be sitting there saying, JD, we do this routinely, and that's great. But some, I know from experience that not everybody does that. So let me give you some suggestions, some examples. So attention, please. This is to everybody. And what I recommend is when you send these litigation hold notices, that you request a response back from your organization, from your people in your organization, responding, saying, yes, got it, working on it. And then calendar some follow-up. Hey, it's been 3 days. What have you done to implement the litigation hold? Because you don't want to lose information, okay? So first here highlighted is any routine or ad hoc deletion of electronically stored information should stop. A lot of organizations have auto deletion or auto retention settings on their systems. In other words, your email that's so old, let's say 2 years old, 1 year old, 6 months old, automatically deletes or automatically goes into storage, okay? You want to work with your IT professionals to stop those auto deletion and those auto retention calendars and functions, because you need access to this information. You got to be able to collect it, identify it, collect it, and then pull it aside and preserve it. So that's what that refers to. The next highlighted section, any failure to follow these procedures may result in severe penalties. What that's talking about is spoliation. I know it's a legal term, but it means the destruction or alteration of evidence. And if the other side's suing your organization and they find out through discovery, which they most likely will, that you've destroyed information or allowed information to be altered or destroyed, then they're going to bring a motion possibly to the court and say, hey, this party ought to be sanctioned for allowing evidence to be lost and spoliated. And that can have some very negative impact on pending litigation. Your obligation to preserve must immediately take every reasonable step necessary to preserve. That's important. It's reasonable steps. You don't have to take unreasonable steps. You don't have to hire and spend millions and millions of dollars with some outside organization. There may be some very reasonable steps that you take within your organization, but dialogue and have that conversation with your outside counsel and your internal counsel to determine what steps are reasonable. But the case law is clear that the courts are looking for reasonable steps. If steps you've taken leads to the destruction of evidence, it's not reasonable. Okay. And what they're referring to is a litigation hold notice isn't asking your entire organization to stop what it's doing and preserve everything. That's not at all what's required. What's required are documents and physical things in your possession that relate to the dispute. So in this case, it would be those documents related to Iron Man and Captain America, but not necessarily Spider-Man, because Spider-Man might not be, or Hulk might not be in this dispute. So your Hulk division and maybe your Scarlet Witch division don't need to do anything right now, because this is only focused on Iron Man and Captain America. You want to define documents, and again, we can help you do that. It's not as simple as just saying, oh, well, we want your files, because your organization may have specialized documents in its systems. It may create specialized documents to track customers, track loans, track accounts that maybe another business might not have. So you want to define documents as broadly as you can, but that certainly includes hard copies of documents, files, but it also includes what we talked about earlier, ESI, electronically stored information. That includes emails, that includes text messages on people's phones, that may include chat messages. Maybe your corporate culture is you chat through Teams or some other app, and you need to preserve those chats because you were talking about, your managers were talking about Iron Man or Captain America. And so those are potentially relevant information. But you're going to want to define that broadly, and your IT professional can certainly help you find and identify those relevant sources of information. Preservation in place and in the current form. What they're talking about here is your obligation to preserve all relevant paper and electronic documents as they exist today. We can't go and change their form. I have lawyers sometimes, I'll send a request on behalf of my client for all of your organization's emails related to the Mayflower event, okay? very, very narrow, just this event that we're dealing with in litigation. And I instruct them in the request to produce them to me in electronic format. What does that mean? That means have some IT professional literally copy those emails onto a thumb drive or an external hard drive and produce those to me in electronic format so that I can access the drive and open those up. But instead, what I get sometimes is they'll print all their emails out and then they might scan them into PDFs, okay? That is not compliance. I can tell you that their case law out there says that is not compliance. So you have to preserve that information in your corporation in the format it sits today. If it's searchable on your servers, it needs to be searchable to the party who's receiving a copy of that. And your IT and legal professionals can help you with that. And there's a little bit of a danger here because sometimes when we change the format of a document, of an electronic file, we actually alter it. And that could be spoliation. So we have to be careful that we don't do that. Let's stay out of those traps, okay? All right, continuing obligation. As some of you know, litigation, certainly complex commercial litigation, can last many, many months and sometimes years. I've had cases last multiple years. And your obligation, just because litigation's lasting a long time, doesn't mean your obligation to preserve information goes away. So you want to continually communicate with those document holders, or as we call them, document custodians. You want to communicate with your organization and remind them periodically that, hey, Iron Man and Captain America are still fighting. And I know it's been a long time, but they are still fighting. And so we need to continue to preserve information. And your IT professional can help you do that in a way that doesn't cripple the rest of your organization and cause problems in your continuing workflows. Okay, so make a note to continually communicate, maybe even calendar every 3 months to regroup and meet with your organization and your document custodians to remind them, hey, they're still fighting, so we have to continue to preserve this information. All right, I hope that was helpful. Well, what does notice look like? Notice to your organization. In other words, what type of events, JD, do I have to look for that are going to put my organization on notice? Okay, here's some examples. There may be others, but how about a summons and complaint served on your organization? Yeah, that's notice that there's a problem and there's litigation. That's an easy one, right? How about another easy one? A subpoena. You receive a subpoena under Federal Rule 45 or North Carolina Rule 45, and you're required to produce documents. Okay, that's a pretty easy one too. What about a notice of investigation from the state AG's office, maybe from some regulatory body, from some licensure authority? A notice of investigation. That's another pretty easy trigger. At that point you've received notice. Okay. What about a notice of audit from NCDOR or the IRS? That's another one. What about a threat by an employee? I'm going to get you. You don't pay as much as Wally World down the street or Chicken Filet down the street. I'm going to get you. That might be notice. Yep, that might be notice. Complaint by one of your customers might be notice. Depends on what they say. What about a Google review? What about a really bad Google review? Maybe that's notice. Maybe that's notice of a claim you're going to have against them because the actual Google review was false and it was defamatory and it paints your organization in a false and negative light. Okay. What about social media post? Same thing. Google review, social media post. Maybe that's defamatory, or maybe it's notice to you that there's a real problem out there. What about an accident, an injury, or other event? We talked about that. What happens if one of your employees gets hurt in the warehouse or on the job? That very possibly could be notice. And you need to go ahead and document those occurrences. Okay. So knowing that litigation is coming, what are some other things that your organization can do to be ready for litigation or that claim, to deal with that claim? First of all, I think you need to assess the needs and the priorities of your organization. For some, avoiding litigation is paramount because that would be really bad to your name. For others, sending messages to future similar claimants or future similar parties that might get sued is really important. There are priorities for your organization that you need to assess and determine and use those to determine your hierarchy of what you're going to do. I suggest that you budget some for litigation. I can tell you from talking with my clients, litigation's expensive. It's very expensive. And it can be expensive. And sometimes, as I've told clients in the past, when that train leaves the station, in other words, when your company gets sued, you may not be able to get off that train until it stops at a stop long time down the way, down the track. Okay? And in the meantime, there are things that you have to do to avoid a negative result in that litigation. So it can be expensive. So maybe you do this. Maybe you have a risk management budget, or maybe you have a litigation budget. But I suggest you think about that. And how do you set the amounts in that budget? I don't know. I don't know if it's a percentage of revenue. I don't know if it's based on how much you spent last year or the 5 years before. But putting some money away for that rainy day when it comes is important. I think making risk assessment and risk response a priority in your organization is really, really important. The organizations that I see that are successful in this make this a real priority. So they're already talking about and documenting those triggers and those notices, and they're already have things in place or systems in place to preserve documents and preserve information when those notices are triggered and when the duties are triggered. So these organizations do well. What they do is they assign people to manage the risk. You may have that function in your corporation. You may have a risk management professional or a risk management officer, and it's her job to assess and document risk. That's great. Or that may be a function of your in-house legal counsel. Also, you may not have that, and you may have to assign that to somebody, and that becomes one of the functions added to her job. But be careful about that, because you don't want it to be something that just gets set to the side. So regular meeting about this, regular reporting around this can be important. You want somebody in your organization or some people in your organization who are responsible for identifying the company's claims and deadlines. What happens if the company has a claim? Let's say you're a contractor and you haven't been paid on a job. All right. Well, you have 180 days to file a lien from the last day of work to file a lien on a piece of property. Who's watching that in your organization? Or is that just something that hopefully you'll catch at a quarterly meeting? I would suggest to you to be more intentional about that so that those types of things don't fall through the cracks. Because we get phone calls from contractors who want us to file liens and the time's expired. I'm sorry. We can maybe file a claim, but we can't file that lien. And then the statute of limitations. Statute of limitations under the law is the amount of time that a party has to bring a claim. So how long do they have, and who's watching that in your organization to make sure that those statute of limitations don't expire? Okay. Legal team can be an asset, whether that's an outside legal team or an internal legal team, or combination working together. They can help you recognize risk, document that risk, avoid risk, and respond in a timely fashion. All right. Who should be involved? Well, that's up to your organization, but certainly it ought to be the manager or managers who oversee the particular issues that are the problem, or from where the problem arises. If it's an employee who was injured in a warehouse, it's your warehouse manager. If it's a contract dispute, it's going to be the manager whose function it is to manage that relationship and that contract. Certainly, it can be HR. When I was in-house at a large telecom company, we had an entire organization that was devoted to HR, and it was their job to manage HR issues. And they came to us often to talk about hiring, firing, discipline, all those issues in HR. That's important. Accounting is an important function, and they might be involved in risk management, tax decisions, timing of filing of returns, of payment of taxes, of making revenue payments, etc. They're going to be an important piece of this. IT is critical, whether you have an internal IT team or a for preserving an outside IT team. Whether you have internal or outside IT team, they're going to be really critical to you in preserving information, helping you get into your systems and identifying those documents that are actually relevant to the dispute, and then preserving those, but also not interrupting the continuing flow of your business. Compliance officers, some companies have compliance officers, and these officers are critical in making sure that you're complying with regulatory determinations and laws, and making sure that you're following all the proper procedures your organization must follow. And then finally, legal outside and inside counsel. They're going to be critical to you in helping with this. And so I would suggest that people with those kind of functions should be part of this internal team who are assessing risk and getting your organization prepared for litigation. Okay. All right. Let's go to IT real quick. What systems might be involved? You're sitting there saying, well, wait a minute, JD, we had a claim filed, and I don't even know where to start. What systems, where am I going to find relevant information? Well, your IT professionals are going to help you. And certainly it's going to be your IT systems, whether it's your servers, your email servers, your document servers, your short-term and long-term storage. All of those systems may be implicated. So you need that IT professional to guide you through that. Document storage. Is that storage online, or is that hard copy storage? Do you have physical files? Some companies function with physical files. It's just still in 2022 that their business is such that they need physical paper, and they store that in physical files. Emails. We talked a little bit about that, but God, doesn't it seem like you receive hundreds or thousands of emails a day? Most of them are junk. Yeah, those may potentially be responsive, and you've got to got to look and see if you need to preserve that information. Texts and chats, we talked about those. What about text messages on personal phones? Well, possibly if that's a business text that goes on a personal phone, then personal devices may be implicated. The real risk with chat messages is oftentimes they're not preserved for very long. So you're going to need to get in there and grab those quickly. Other information databases may be implicated depending on what type of business you do and what type of records you keep and generate. And then outside devices. Do you have salespeople or outside who are traveling? Do you have other offices? Maybe maybe Charlotte's your home office, but you've got offices in Asheville and Raleigh and Durham and Greensboro as well. Maybe you've got offices all over the country or salespeople all over the country, maybe outside the country. So you're going to need some help in identifying all those folks whose information is potentially responsive and relevant, and capturing that information and preserving that information. All right. What type of notices do we need to and I'm sorry, somebody put in a note in the text, and I think I said 180 days to file a lien. It's 120 days. So if I'd said 180 days, I apologize. It's 120 days to file a lien. I was thinking about, the reason I said 180 days is because I was thinking about an EEOC claim and an employee's time frame for filing a potential Title VII claim with the EEOC. So I apologize. It's 120 days. And thank you for whoever sent that note in. And that's North Carolina law. Of course, if you're in Tennessee or Virginia or South Carolina, that deadline could be different. So thank you, whoever sent that in. What about notices? What other notices besides the litigation hold notice that we talked about a little while ago? What other type of notices may be important for your organization to give? Well, how about insurance companies? You know, under most insurance policies, commercial general liability insurance policies, there's a notice requirement in there, and it's not typically an amount of days, though it may be in your policy. You need to read that. But it's reasonable notice. You have to give the insurance company reasonable notice of your claim. And there's a lot of litigation out there in North Carolina about what is reasonable notice. And it's notice typically that gives the insurance company enough time to decide what it's going to do with the claim and either hire counsel or take some other action. So you want to make sure that you're providing that notice very quickly. What about regulatory bodies? Different regulatory bodies and licensing authorities require that you provide notice of a claim or a potential claim, and provide that to them on some time frame. So you need to be aware of what those time frames are, because you don't want to have a claim and then also have the added claim of the regulatory body coming in and saying, hey, you didn't give us notice of this. So you got to watch out for that. Also, some of your contracts that you have with your business partners, other businesses, your customers, they have contractual notice provisions in them. Maybe it's 1 year, maybe it's 90 days. Whatever that contractual provision is, you need to give notice or make those claims within that period of time in order to comply with that contract. Oftentimes, internal boards, shareholders, partners or members of an LLC will want notice more than maybe an annual meeting. So maybe you have some requirement in your shareholders agreement or your operating agreement that requires you to provide more timely notice of issues and claims to those parties. And then loan agreements. I'm thinking of maybe a mortgage where you have to provide your mortgage lender notice of any lien on the property, and a duty to keep those liens off, or any type of other loan requirement or notice requirements that might be in a loan agreement if certain things happen within your organization. Those are all case-by-case basis based on those documents and those regulations. But make sure you've got somebody who's watching those to make sure those notices are provided, because you don't want to have the added problem of not providing that notice and lose out on, for instance, insurance coverage or triple loan covenant and end up in a situation with a lender. All right. We talked about this a little bit, but litigation can be really, really expensive. But I can tell you that litigation that you ignore can be even more expensive. And so just some examples of timelines. In federal court, typically when a lawsuit's filed, you have 21 days to respond to the summons and complaint. You'll want to look on that summons that you're served with and make sure that that's what it says on there. In state court, you typically have 30 days. Again, you want to look on that summons, and it says on there how long you have to respond to that summons and that complaint. In a subpoena, typically you have 10 days under Rule 45 in state court to file objections to that subpoena. Under Rule 45 of the federal rules, you have 14 days typically to file an objection, or with both of the subpoena rules before the time that the response called out in the subpoena occurs. So you want to make sure that immediately upon receiving or being served with a summons and complaint or a subpoena, you want to immediately alert your outside counsel so they can take action very quickly, and then alert your insurance company so they can take action very quickly, because these windows can close very fast. And there may be extensions of time you can get. You just want to make sure that you ask for those within the period allowed. What are some of the consequences for not responding or for responding late? Potentially default can be entered. Some of you have in your business, you sue customers who default on agreements, and you've had this experience where they didn't respond, let's say to a state court claim within the 30 days allowed. They can forfeit their ability to appear and assert defenses if they don't answer in time. And then they're subject to potentially entry of default judgment, where the court could enter judgment as requested by the claimant or the plaintiff. And so you want to try to avoid those situations at all costs, especially when you have defenses that you want to assert against those claims. And then with regard to the subpoenas, you don't want to miss your opportunity to respond, because you don't want to waive any potential objections that you have to the types of documents that are requested. Maybe they're confidential, maybe they're trade secret, maybe they're protected by the attorney-client communication privilege. You want to be able to assert those, or maybe they're asking you to do something that's onerous and expensive on your corporation. You want to object to that. Also, it might be that the timing isn't reasonable, or the timing for somebody from your organization to appear might not be reasonable for your organization. So you want to make sure that you object in those times. And of course, when you receive a regulatory notice, licensure notice, you don't want to miss those deadlines, those response deadlines, or don't want to miss asking for an extension of those, because there could be potentially fines, costs, and other negative impacts to your licenses or by the regulatory authorities. So you want to make sure you meet those deadlines. So I'm getting towards the end of what I've wanted to talk about. So I have a question here, and it asks me, what is the process for grabbing chats quickly? That is to preserve them. And I'm not an IT professional, so I don't know. But your IT professional can advise you on that. I'm not sure what the retention schedule is on your internal chats. It may be 7 days. It may be 14 days. Go ahead and ask your IT professional ahead of time and ask them what steps need to be taken, how quickly they need to be notified when a claim arises or you think a claim is going to arise, so that you can engage them quickly. But I think a reasonable step, this person asked, if all else failed and all you could do was capture screen captures, print screens, go ahead and do it. That's preferable to losing the chats completely and having them be wiped, deleted and wiped and not accessible ever again. At the very least, you've captured them. But I think the better practice would be to talk to your IT professional and ask them how quickly they need to be engaged for your particular system, because I don't know. They're all a little bit different. And so I hope that answers that question. And again, I apologize. On that 180 days. I'll be clear, it's 120 days to file a lien. It's 4 months to file a lien in North Carolina. So whoever correct me on that, you get a bonus for today's attendance and for correcting the speaker. I appreciate you doing that. But the point there is that deadlines for filing claims can come very, very quickly. Statute of limitations vary for different claims based on how the legislature sees them. They're not all 3 years in North Carolina, and in other states. In other states, they're 2 years, 1 year, 4 years. It just depends. It depends on where the claim arises. It depends on the contracts involved and whether there's a forum clause, whether you have to file suit in North Carolina or file suit in some other jurisdiction, whether you're getting sued in another jurisdiction. And so when a claim arises or when you think you have a claim, you want to begin the process of analyzing that very quickly so that you don't lose your rights by the expiration of those deadlines to file. So I have enjoyed spending this afternoon with y'all. I hope you enjoyed Captain America and Iron Man again. My kids and I love those movies, so I'm thankful that we could re-engage the Marvel universe as an example of a litigation hold. But if you have any questions, you can interact with us on Twitter, social media, at our website, and of course, every time we do one of these webinars, please feel free to log in. Let us know how we did. Let us know if you have any questions. I'd love to hear from you by on phone, by email, however. So thank you for your time. Have a great afternoon and get prepared for litigation.